Good evening, everyone, and welcome to session 2 of Constitutional Revival. I'm so happy that you are joining again. I have gotten some great feedback in the last 2 weeks about what we have done and what we are doing, and that is so encouraging. Several of you have sent checks, and we are so grateful for that. We need a little under $1,200 to be able to stay on the webinar for a year, which is a great deal. And we're a little over 800. So we're going to keep plugging on that. Everything we do, of course, is strictly donated, our time, and any contribution that's made is strictly to keep us on the webinar. I again thank Joanne Woodard and David Hagar for making this whole thing go. David Hagar owns Beyond Innovative Technologies and Consulting and does a great job. We have set up a Venmo account, and we are also on Facebook for contributions, and we are working on the YouTube channel as well as the webinar website to make them able to receive contributions. But in the meantime, if you don't want to use Venmo, you can do Venmo, but if not, you can send a check to Royal Alexander. Please note Constitutional Revival and P.O. Box 1837, Shreveport, Louisiana 71166. Again, Royal Alexander, please notate Constitutional Revival, P.O. Box 1837, Shreveport, Louisiana 71166. So, and another thing, I know this is an interactive website, and I went kind of long last time because we were kind of pumped up about the Declaration of Independence, but I want you to know I'm going to go pretty much the full hour, and certainly from 7 to 7:30. If anyone sticks around and wants to ask some questions through the webinar, I'll be happy to answer them. Or you can always email questions and I will answer them to constitution.royalalexander@gmail.com. Again, constitution.royalalexander@gmail.com. And if you send me a question that you have, I will answer it as soon as I can. So let us begin. Just a quick recap of last time. You remember, if you were here, you will recall it. If you weren't, I want you to know, we talked about constitutional and statutory interpretation. We talked about the two main forms of interpreting a statute or the Constitution, which is judicial activism, or what's called loose constructionism. This idea that the Constitution is a living organism and it's always changing, and you can plug in, for example, 2020 values to our Constitution. That's the judicially active way, loose constructionism, or strict constructionism, which searches for the original meaning and what the text of the words mean. What is the plain meaning of the words? And originalism, what did those words mean at the time either the Constitution was drafted or the legislation was drafted, the law. So we talked about judicial activism and strict constructionism. We left off with the Declaration of Independence, and I just want to reiterate a couple of things. Again, the concepts contained in the Declaration of Independence are profound. They had never been, and never in the same way have never been, but certainly prior to Thomas Jefferson writing it, had never been included in a founding document, such novel, really profound ideals. And as I said before, many people consider the Declaration of Independence to be the promise and the Constitution to be the fulfillment of the promise. Declaration is the promise, the Constitution is the fulfillment of the promise. So what made the Declaration of Independence so profound? Well, the introduction is amazing. When in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, meaning with Great Britain, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the reasons, the causes which impel them, which motivate them to separate from Great Britain. And again, this next couple of sentences has changed the world. It has had a profound impact on the world. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights. Unalienable just means they can't ever be alienated from us. They can never be divested from us. Simply by being living, breathing human beings, we possess certain intrinsic dignity, worth, and rights. We're endowed by our Creator with certain unalienable rights, and that among these are life, liberty, and the pursuit of happiness. Not the guarantee of happiness, but the pursuit of happiness. And that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. And you can ask, as I said 2 weeks ago, whether our government today has our consent. They derive their just powers from the consent of the governed. And that when any form of government becomes destructive of these things we just went over, our rights to life, liberty, and the pursuit of happiness, and our unalienable rights, whenever any form of government becomes destructive of those ends, it is the right of the people to alter it or to abolish it and to institute new government which will protect those rights. So it's brilliant. Now, people say, well, they talk about we hold these truths to be self-evident that all men are created equal, but many of those people, Jefferson included, were slave owners. That's right. Which makes the fact that they wrote this, that they put this ideal into our governing document, all the more profound. You're right. We didn't meet this standard for many years, but the fact that it is the standard is what is miraculous. That is what is profound. That Jefferson at that time still wrote, we hold these truths to be self-evident that all men are created equal, even if we wouldn't realize that for many decades to come. It's still profound that it's in this document. And as I said last time, Jefferson rolls through and talks about in every stage of these oppressions, we've petitioned Great Britain for redress. And every time those petitions for redress have only been answered by repeated injury. And that's the definition of a tyrant. And he goes on to say, again, he closes by saying, and for the support of this declaration, with a firm reliance on the protection of divine providence, we mutually pledge to each other our lives, our fortunes, and our sacred honor. That's all very powerful because many of these men, the 56, paid a dear price for having signed this document, personally, professionally, but they took great courage. And I also mentioned John Hancock signed his name particularly largely so that the king could read his name without even needing to put his glasses on. That's why John Hancock signed his name so broadly on the Declaration of Independence. So that is the Declaration of Independence. That is a recap of last time. And today we're going to start the Constitution. We're going to start with Article 1. And this is the legislative part of the Constitution. Tonight is going to be Article 1 sets up the legislative branch. And remember, we have three: legislative, executive, and judicial. But we can't really begin the Constitution without talking about the preamble. You remember the preamble to the Constitution? At one time, we all memorized it. The preamble: we, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty, a word we'll see through the Declaration and through the Constitution. Secure the blessings of liberty to ourselves and our posterity, just meaning those who will follow us. Do ordain and establish the Constitution for the United States of America. what a succinct way of setting up this major thing that was coming after it. And what I like is we, the people of the United States, in order to form a more perfect union, they realized they probably were never going to achieve perfection, and that we would always be trying to achieve a more perfect union. And we've made many changes in the lawful political way, according to our democrat system, based on a constitution, because we are a republic. We are a form of representative democracy based on a constitution. There is a way we make changes so we can create a more perfect union. But those words tell me they knew in the beginning, this is not perfect, but we're gonna, if you will follow the things we have laid out in this constitution, that is your best chance to create a more perfect union. And what are we trying to do? Establish justice, ensure domestic tranquility. Look around the country today and ask whether you think we have domestic tranquility. Provide for the common defense, promote the general welfare, and secure the blessings. Again, another reference to God, the blessings of liberty to ourselves and our posterity. Do ordain and establish this Constitution. So in a very concise, succinct way, the Constitution broadly sets up what's coming. So let's go see what's coming. Article 1, Section 1 of the Constitution provides that all legislative power herein granted shall be vested in a Congress of the United States, and it shall consist of a Senate and a House of Representatives. Article 1, Section 1 merely states we're setting up the legislative branch. All legislative powers herein granted, meaning herein in this Constitution that are granted, are going to be vested in the U.S. House of Representatives and the United States Senate. And we know that the Constitution, it first vests all federal legislative power in a representative bicameral house. And we know bicameral just means it's two houses. The first house is the U.S. House of Representatives. The second house is the U.S. Senate. And central to this social compact that we all joined as Americans and that we're all a part of because we live under this Constitution, central to that social compact, this lawmaking institution that they're setting up here, the Senate and the House, will form the foundation of the federal government. And it will allow the people's representatives, both the U.S. representatives and the U.S. senators, allow them to act together for the common good. And it also establishes several fundamental features which we're about to go over. So Article 1 of the U.S. Constitution is setting up the legislative branch, the U.S. House and the U.S. Senate, and all legislative powers will be vested in those two bodies. So that's pretty cool, you have to admit. Article 1, that's Article 1, Section 1. Article 1, Section 2 goes on to specifically address the U.S. House of Representatives, of which there are 435. We have 435 members of the U.S. House of Representatives. I will say quickly, and I'm sure I will repeat it, Louisiana has 6 congressional seats. Let me back up. Louisiana has 6 U.S. House seats and 2 U.S. Senate seats. So we have 8 electoral votes. And later we're going to get to the Electoral College, but I just want you to know the reason Louisiana has 8 electoral votes is because we have 6 U.S. House of Representative members and we have 2 senators, as every state does, 2 senators. The 6 and 2 make 8. Louisiana has 8 electoral votes. Anyway, back to Article 1, Section 2, the House of Representatives. The House of Representatives shall be composed of members chosen every second year. So locally, our congressman is U.S. Representative Mike Johnson. Mike is he was first elected in 2016. He was reelected in 2018. He is up for reelection in 2020. And if he's reelected, of course, he will be up again in 2022. That's every 2 years. Every member of Congress is up for every 2 years. So it turns over, and it's supposed to be the people's house. You see what I'm saying? And I'm going to explain how the Senate is supposed to be a separate kind of deliberative body than the House of Representatives. Its rules are different. Its terms are 6 years in the US Senate, not 2. The House was supposed to be the House of the people. It's where the people's representatives get gathered. They were closest to their own population, the US House of Representatives. So it's oftentimes more tumultuous, more raucous, although the Senate is becoming more that way, I would have to say today. But the US House is up every 2 years. You have to be reelected. So you are perpetually running for office. But I always believe that if you're doing a good job representing your congressional district, that's campaigning all the time anyway. Every time you go and help one of your constituents, every time you go speak to a group, cast a good vote in the Congress, or help someone with veterans benefits, Social Security benefits, or any other kinds of benefits, you are, in a sense, campaigning. You are doing the best you can for your constituents. So, but you're still up technically every 2 years. So there's an election this year, again in 2022, 2024, 2026. Every member of Congress is up every 2 years. What are the qualifications to be elected to the US House of Representatives? You have to be 25 years of age. And you have to have been a citizen of the United States for 7 years. 25 years old, 7 years a citizen of America, and you have to be an inhabitant of the state you're going to represent. So you have to be living in Louisiana if you're going to represent a congressional seat in Louisiana. Let's see. When there's a vacancy, as there are sometimes, the governor calls for a special election. That's different from the Senate. The governor appoints someone to fill the Senate seat till the next election, but not in the House. If there's a vacancy in the US House, if Congressman Johnson went on to do something else and there was a vacancy, the governor of our state would call for a special election for the seat that is Shreveport, which is the 4th congressional district here. So that's important. The House of Representatives, like the Senate, gets to choose its speaker. It's not called a speaker in the Senate, but we'll get to that in a minute. In the House, though, it's called a speaker. The current speaker, God love us, is Nancy Pelosi. She is the Speaker of the U.S. House of Representatives, chosen by a majority of the members, and they can choose other officers. They have majority leader, majority whip, and they work their way on down. Each house gets to set those things up, their own self-governance in their own house. But an important thing is the House has the sole power of impeachment. Now that's important. And you know, we've only had 4 presidents been impeached. And there were Andrew Johnson, who just missed being removed from office, Richard Nixon, who resigned before he was removed, so we never got to that point, Bill Clinton, who was impeached but was not convicted, and so he was not removed from office, and then Donald Trump, who was impeached but was also not convicted and therefore not removed from office. But what it means to have the sole power of impeachment means the House of Representatives will draft the articles of impeachment. They won't try the case of impeachment. That's the Senate's responsibility. But the House will draft the articles of impeachment. And since it just happened not long ago, you probably remember the U.S. House of Representatives drafting a couple of articles of impeachment. I'll avoid commenting on the validity of all of that in my view, but they did what the House is required to do. The House drafted articles of impeachment and sent them to the Senate. But of course, you remember they didn't send them immediately, which was different. That had never happened before. So that's what the House does. Every second year they're elected, you have to be 25 years old. You have to be 7 years a citizen of the United States and live in the state in which you're going to be elected, from which you're elected. If there's a vacancy, the governor calls a special election, and the House can pick its own speaker and other officers, and it has the sole power of impeachment, which means it can draft articles of impeachment, which it then sends to the Senate. All right, that's the House. Article 1, Section 3, the Senate. The Senate of the United States, and this is fascinating and this is important. And by the way, I hope you're taking notes. The Senate of the United States is composed, every state has 2 senators. And this is why this is so important. During the drafting of the Constitution, the big states didn't care much about the small states, and the small states did not trust the big states. So they came up with what's called the grand bargain. And what was the grand bargain? It was to create 2 different houses. One would be the U.S. House of Representatives, which would be based upon population of a state. The other would be the U.S. Senate. And regardless of population, every state has 2 votes. The reason that's so important is because Rhode Island, Louisiana is a small state. We have about 4.5 million people. Rhode Island is way smaller than we are. Rhode Island has about 1,059,000 people. That is a small state, 1,059,000. But in the United States Senate, Rhode Island, with barely over 1 million people, is just as powerful as California. That has 32 million people. You see the brilliance? In the U.S. Senate, Rhode Island, tiny little Rhode Island, is just as powerful as California. Now, in the House of Representatives, California has about 57 congressmen. And of course, Rhode Island, I think, just has 1. Every state has to have at least 1 member of the U.S. House, no matter how small. You got to have 1. Wyoming is another very small state that just has 1, but it has 2 senators. But still, it's fascinating. That's how, otherwise, the small states never would have been willing to support the Constitution. They just said, we're just going to be trampled by the big states because they have most of the population. So in their genius, they decided, we're going to create 2 houses. We're going to apportion 1 house, give it political clout based upon population. The other one, we're going to say everyone is equally powerful. California gets 2 United States senators, and tiny Rhode Island gets 2 United States senators. So they're equal. But in the House, obviously, California has 57 and Rhode Island has 1 member of the U.S. House. So that is fascinating how they did that. Okay. Originally, senators were elected by the legislature, but that was later changed. And it was the 17th Amendment in 1913 that started making senators popularly elected in their respective states, just as U.S. House members were. Some people didn't like it. They said, now you've democratized the Senate. But the Senate is still quite different in many other ways. But, and let me explain what I meant earlier about the difference in the House, kind of the way the framers saw it. The U.S. House was to be closer to the people, elected every 2 years. It was kind of the tempest in the teapot. The tea would sometimes get so heated. We're the salt of the earth people. We're doing the people's will. We're closest to the voters and the people in our districts. You Senate over there for 6 years, you're kind of the upper house, even though we don't do an upper and lower house in this country. That's one of the things we don't do. But the Senate still, I assure you, thinks of itself as the upper house. But the U.S. House is considered the cup, the saucer. I mean, the cup of tea. Sometimes that cup of tea, if it gets too hot, boils over into the saucer. And the Senate is the saucer. The Senate catches the spillover and kind of calms it down, is the deliberative body. So like a tempest in a teapot or a tempest in a teacup, sometimes when the House spills over, the Senate catches it in the saucer and calms it down, makes it more deliberative. And that's really a major separating fact of the two houses of Congress. Of course, the Senate has only 100 senators, 2 for every state. 50 states times 2 is 100. Their elections are staggered. They have 6-year terms, but everyone comes up every 2 years. So this year in Louisiana, for example, U.S. Senator Bill Cassidy is up in 2020. In 2 years, Senator John Kennedy will be up. And in 2 years after that, a whole other third of the Senate's up. So every 2 years, 1/3 of the Senate faces re-election. And it's staggered It's always turning over every 2 years. And if you see, 2 times 3 is 6. So by the time the last cycle finishes, it's time for a new 6-year term, therefore an election. So the Senate terms are 6 years, but they're staggered. And every 2 years, another 1/3 of the senators are up for re-election. 2 years later, another 1/3 are up for re-election. And 2 years after that, another 1/3. And that makes 99, and there's 100 senators. So somewhere in there, one of them, they fit that person in also, because it all works out. The numbers work out for 100 senators, but they do come up 1/3 of the Senate, 1/3, and 1/3 of the Senate every 2 years. So those staggered terms, their terms are staggered, but they're over 6 years. And the reason the framers wanted to give them 6 years is because they wanted them to be able to take the longer view. You're not just facing re-election in 2 years. You're not facing re-election until 6 years. So this is going to be the calmer, more deliberative body, the U.S. Senate. And in many ways, it is. So what are the qualifications to be a United States Senator? Well, you have to have attained the age of 30. You have to be 30 years old. You have to have been 9 years a citizen of the United States, and also be an inhabitant of the state you're going to be representing. So you got to be 30 years old. You have to have lived in been a citizen of the United States for 9 years, and be an inhabitant, be living in the state you're going to represent. So those are slightly different than the qualifications for the U.S. House. 30 years old, and we've had some people elected to the Senate in 29, and they had to wait to be sworn in until they turned 30, which is very interesting. By the way, the Senate has a president pro tem, but the vice president is considered the president of the Senate if only he doesn't get to cast a vote except if there's a tie. The vice president only casts a vote in the U.S. Senate if there's a tie. If there's not a tie, he never gets called in. But the Senate itself has a Senate pro tem, just like the House has a speaker. The Senate, its head is the president pro tem, and all pro tem means is for a time. Right now it's Chuck Grassley, Senator Chuck Grassley from Iowa, but it rotates. In whatever time period it is, in maybe 2 years, another senator will become the Senate pro tem. But Chuck Grassley is the Senator pro tem, which means for a time. Now, this is interesting. What is the presidential succession? We know that if the president is incapacitated or dies, the vice president becomes president. But if both the president and vice president are incapacitated or die, then the Speaker of the House is second in line. After the president, the vice president is first in line. The Speaker of the House is second in line. Right now, that would be Nancy Pelosi. Whew. So the Speaker is second. The president pro tem of the Senate is third. So if something happened to the president, the vice president, and the Speaker of the House, the president pro tem of the Senate, who right now is Chuck Grassley, Senator Grassley from Iowa, Senator Grassley would become president of the United States. And just out of curiosity, what happens after that? If something happened to the president, vice president, Speaker of the House, and the president pro tem of the Senate, it would next go to the Secretary of State, who is Mike Pompeo. Mike Pompeo, the Secretary of State, would become president of the United States. And just out of curiosity, the last one, if something happened to the president, vice president, Speaker of the House, president pro tem, and the Secretary of State, who would become president? The Secretary of the Treasury, who is Steve Mnuchin. And I know you've seen his name in the middle of the virus and all the federal spending we've seen. He's been in the middle of it. So Steve Mnuchin, the Secretary of the Treasury, would become president. So it goes on and on, but that's enough for now. It goes from president to vice president, Speaker of the House, president pro tem of the Senate. Then it goes to the Secretary of State, and then the Secretary of the Treasury. And that's all I found all that very interesting. So again, the Senate's supposed to be a different body. What are some of the Senate's major powers? The Senate shall have the sole power to try all impeachments. Okay? Remember, the House has the power to bring the articles of impeachment, to bring them forward, to pass them. but they don't try them. Once the House passes them, they get sent to the Senate. And remember, again, once the House passed it regarding President Trump, Speaker Pelosi held on to those articles for a while. It looked to me like she was waiting for the Senate to do certain things that she wanted it to do before she sent the articles of impeachment over. But whatever the case is, we'd never had a situation before where a Speaker of the House held on to articles of impeachment for a period of time before sending them to the Senate. But Speaker Pelosi did that. Anyway, the Senate has the sole power to try impeachment. And what that means is conducting the trial, the actual trial, and deciding whether the individual is to be removed from office. And keep in mind, people sometimes get this wrong. Once those articles are passed out of the House, the president has been impeached. But the difference is he hasn't been convicted and removed from office. All has happened once the House passes those articles is the president has been impeached. But once they go to the Senate actually tries the case. It tries the impeachment case. And it has the sole power to do it. That's why when Speaker Pelosi was not passing those articles on and she was saying, I want certain things to be a certain way in the Senate before I send the articles of impeachment over, she doesn't have any power to do that. No speaker does. The Senate is its own body, and the Constitution says the Senate has the sole power of impeachment. So it gets tried. The Chief Justice, Roberts, as you recall, presided over it. And they heard the evidence. They heard the case for several days. And it would take 67 senators to vote to convict and to have removed President Trump or President Clinton or any president. 67 senators. It takes a supermajority of 2/3. And obviously, there were not that many senators who wanted to convict President Trump or President Clinton, so they were not removed. And the impeachment failed. So I'll tell you one quick note that you'll find interesting. Under one of the Senate impeachment rules from March 2nd, 1868, that's just a few years after the end of the Civil War. March 2nd, 1868. We know the impeachment managers shall be introduced to the bar of the Senate, and they'll signify that they're ready to exhibit articles of impeachment. And the presiding officer of the Senate tells the sergeant at arms of the Senate to make the proclamation and then repeat these words. All persons are commanded to keep silent on pain of imprisonment. So the sergeant at arms tells the senators, those 100 senators, who are really very powerful people, you all are to sit there quietly under pain of imprisonment. And that got read out loud during the Trump impeachment trial. And I always found that kind of amusing that these senators, who are highly energetic, highly intelligent, capable people, I certainly don't agree with all of them, but they are highly capable, highly intelligent people. They're forced to sit there. They can't do other work. They can't look at their phones. They can't be distracted. They have to sit there and listen. Or I guess they could daydream, but they sure can't be looking at their phones, or they can't be doing other work. You know, they can make notes of what they're hearing. I guess they could doodle, but they cannot be distracted because they're commanded to keep silent and pay attention on pain of imprisonment. So I just love watching those senators who go 1,000 miles an hour have to actually sit in those chairs. Some of them are 200 years old. Those desks are the same desks Abraham Lincoln sat in and other very famous members of the U.S. Senate sit in those desks, which are not particularly comfortable because they rarely actually sit in them. But they have to sit in them during an impeachment trial. So that is all very interesting. It takes 67 senators. Now, keep in mind, if an official is removed, that's all that can be done to them right there, right at that moment. They're disqualified from holding any other, they're not only removed from the presidency, they're disqualified from holding any other office of honor, trust, or profit in the United States. So if they're removed based upon an impeachment, they can't ever serve in the Congress again. But even though that's all they face from the impeachment, of course, that's pretty major to be removed from office, to be removed from the presidency. the party convicted will still nevertheless be liable and subject to indictment, trial, judgment, and punishment. Now, keep in mind, again, no one is above the law. That's what this is about. Once they're removed, that individual may still be prosecuted criminally or sued just like any other individual, because no one is above the law. But the interesting thing is, it's really a major thing to indict a sitting president. And it's not because of the individual, it's because the sitting president represents 1/3 of the federal government. He's the chief executive. He or she is the head of the executive branch. And when you remove them, it's essentially one branch, the legislative branch, the House sending the articles over, the Senate trying the impeachment. It's essentially one legislative branch telling the other one, your president's going, we're removing. That's a huge separation of powers issue. Because remember, the three branches are supposed to stay in their own lane: legislative, executive, and judicial. And when essentially the legislative branch, again, the House drafting the articles, the Senate trying the articles of impeachment, remove a president, you're telling one branch of government, we're removing the head, we're removing the figurehead of an entire 1/3 of our government. That's why it's so dicey, it's so uncertain about whether a sitting president can be indicted. I don't think it's a good idea, especially because they can still be liable after their presidency. But politics is vicious, and the parties, if they think they can get away with trying to remove a president, they may do it. So that's why I think it's the wrong step to try to indict a sitting president. I do, because it's not about the individual. It's because they represent 1/3 of our Constitution, 1/3 of the power structure in our country. They are the executive branch, legislative, judicial. Each are 1/3. So that's why I don't think it's a good idea. Okay. And I know I got a little time. Okay, good. We're making a little time. But I want you to know these things because it's important. Then you'll put the pieces together. Regarding elections, the states set like the time and place, for example, of elections, but the Senate comes in to be sure, if necessary, that the right to vote, for example, is being protected. So the legislatures of a state will set the time and date of an election, but the U.S. Congress, the U.S. Senate, the federal government, the legislature can come in and say, you know what, you're denying some people the right to vote. Now we're getting involved with your elections. So the state can set the basic rules, but Congress has the right to change those state rules in order to protect the vote. And that power derives from things like the Civil Rights Act of 1957 and the Voting Rights Act of 1965, which we talked about a little bit before. So that's how elections, the basic who, what, when, where, and why gets to be handled by the states regarding elections. But if there's any encroachment on the right to vote, then the Congress gets to get involved. So another thing is the Congress has to assemble at least once a year. It usually does far more than that, but the Constitution requires the Congress, the House and the Senate, to assemble at least one time a year. But other than that, as a general rule, Congress determines how frequently it will meet. And usually it starts each new Congress on January the 3rd of each year, unless the members specify otherwise. So they got to meet once a year, and they can generally set their meeting times. All right. Article 1, Section 5, the powers and duties of Congress. This is interesting because even though they're co-equal branches, they are self-governing. Each house shall be the judge of the elections, the returns, and the qualifications of its own members. And that's going to matter here in just a minute. They get to be the judge of the elections, the returns, and the qualifications of their own members. The Senate of the senators, the House, the Speaker of the members of the U.S. House. A majority will constitute a quorum to do business, but a smaller number can adjourn. Much of that is done by voice vote. As long as no one objects, No roll call vote has to be taken. But this power over its members includes the ability to compel attendance. You can go send some of the sergeant at arms, or usually the Capitol Hill Police, to go grab a member of Congress and force them to come vote. You can compel their attendance, and you can have penalties imposed against you. And it's interesting that the Constitution leaves it up to each house to self-govern. They can also kick a member of Congress out. They can expel a member of Congress. If the Senate, if 67 senators, or whatever 2/3 of 435 is, whatever that number is, if that many members of the U.S. House wanted to expel a member of Congress, they could. Then it doesn't matter that their voters voted for them. A House can say, you've done something so egregiously, we're actually going to expel you from Congress. We're kicking you out of Congress. And that's powerful. Then that seat would be declared open and another election would have to be held. Also, each House shall keep a journal of its proceedings. And from time to time, they have to publish it. In rare instances, they can keep a certain part of their journal secret if there's a matter of secrecy that needs to be preserved, such as maybe a matter of national security. Everything is done by the yeas and nays. Let's hear it for the yeas and nays. If you ever watch on C-SPAN, when it calls, they'll beat the gavel and say, we're coming to a vote. We will have a recorded vote, record the yeas and nays. And that's what they're talking about. Let's see, another important thing is, even though they're own separate independent bodies, when the Congress is meeting, the House of Representatives, or the Senate, they cannot leave for more than 3 days unless they both decide to leave. So Congress can't go out of session for more than 3 days unless the Senate knows and it's going to go out of session too. The framers just thought it's important that they generally be in session at the same time, the U.S. House and the U.S. Senate. Okay, so that is Article 1, Section 5. Article 1, Section 6, and this is always controversial. The senators and the representatives shall receive a compensation for their services to be ascertained by law. It'll be paid out of the Treasury, as everything is. But this is important. Except in cases of treason, felony, and breach of the peace, they are privileged from arrest. Privileged. They can't be arrested during their attendance at a session of their respective houses. So if they're doing something related to their Senate duties in the U.S. Senate, or doing something related to their House duties in the U.S. House, they can't be arrested. And that includes they can't be arrested for any speech or debate in either house. So they could say something very inflammatory, very ugly, what might be defamatory, you might say, on the U.S. House floor or the U.S. Senate floor, but they have protection. They're privileged from being arrested because they did it while they were debating or making a speech in their respective bodies. That's called the speech and debate clause. But they have a privilege not to be arrested except for treason, felony, or a breach of the peace. They could always be, even during their congressional session, even when the Senate's in session or the House is in session. If it's for treason, felony, or a breach of the peace, they could still be arrested. Other than that, it's very hard to move against them. It's also important, the framers didn't want any senator or representative during the time for which they were elected in that office to be appointed to any other civil office in the government. In other words, that's a separation of powers issue. You couldn't be serving as a U.S. senator and still have an official role in the executive branch, because then which master are you serving? Are you in the legislative branch or are you in the executive branch? So you can't do both. If you're in the U.S. House or U.S. Senate, you can't have any other position in the federal government. And you're limited to your salary, no emoluments, no extra things. The only emolument you're entitled to is your salary, nothing else. You cannot have other compensation or perks legally. So the members of Congress are paid for their work from the U.S. Treasury Amendment 27, it prohibits members, though, keep this in mind, from raising their salaries in their current session. So if this current Congress wants to raise its salary, if it does so, it's not going to see the increase in salary into the next Congress. That's because the framers didn't want members of Congress voting themselves a pay raise, which they got to enjoy immediately. They wanted them to, if they were going to do it, they were going to vote it now, and they wouldn't receive it until the next congressional session. Again, so many of these protections are really to protect powerful people against their own weaknesses, perhaps, or poor judgment. So that is Article 1, Section 6. Now, Article 1, Section 7. All bills for raising revenue, and you will have heard this before, have to originate in the House of Representatives. But the Senate may propose or concur with amendments on other bills. But a money bill, a tax bill, a revenue bill cannot originate in the Senate. It can only originate in the House of Representatives. Again, I think the framers were thinking, this House of Representatives, they're reelected every 2 years, they're closer to the people. If taxes are going to be put on the people, we want it to have to be initiated, introduced in the House that's closest to the people. Otherwise, it's easier to remove yourself from taxes. You might say they remove themselves pretty well now, but at least that was the thinking of the framers. Any revenue, tax, or money bill has to originate in the U.S. House of Representatives, although the Senate can propose its own bills or concur with amendments on other bills. It has lots of power too, the Senate. It just can't introduce a revenue bill like that. Has to be in the House. Now, every bill which passes the House of Representatives and the Senate, we know this, but it's good to hear it again, shall, before it becomes law, be presented to the President of the United States. If he approves it, he'll sign it. Then it becomes law. But if not, he returns it. Again, a veto with his objections. He will return it to either the House or the Senate, where it originated. If a bill originated in the Senate, that's where the veto goes. If it originated in the House, it goes back to the House with his veto and his objections. If after such reconsideration by the House and or the Senate, 2/3 of the House shall agree to pass the bill, it shall be sent to the other House. So and that's hard to do, to get 2/3 of the U.S. House to do anything together. But if they do it, it goes to the Senate. And if 2/3 of the Senate, which is 67 senators, if they agree to the same bill, again, they have to be reconciled, which is what a conference committee does. The two bills have to be reconciled. They have to be identical, in other words, and they have to be passed in both of their houses by 2/3, which is very hard to do. Then they become law over the president's veto. And again, the president has 10 days to decide whether to veto something or not. If he doesn't do it in 10 days, it's going to become law. But they don't usually make that mistake. If the president wants to veto, a president usually does that pretty quickly. But he can be overcome by 2/3 of the vote in the House, 2/3 of the vote in the Senate on an identical bill. And it is hard to do, but I think the framers intended it to be hard to do. The framers, by setting it up so that the House, U.S. House, the U.S. Senate, and the president all have to agree to make law, they intended for it to be difficult. Yes, it's frustrating. Yes, it takes years to change things sometimes, but that's what you call building political consensus. A simple majority to overturn the president is not adequate, the framers thought. If you're going to overturn the judgment of the president over something he or she vetoed, you're going to have a supermajority in the House and a supermajority in the Senate. And that's hard to do, and it is supposed to be hard to do. All right. I know that is a lot to swallow, but y'all are very smart. I hope you're taking notes. Okay. That was Article 1, the main points of Article 1, Section 7. And I realize I only have 11 minutes left. We are in Article 1, Section 8. Obviously, we won't get to Article 3, but to Article 2 tonight, but we are making great progress on Article 1. And this is the legislative branch. It's important. There's a lot of specific powers that I want you to know. And I'm just going to go through them now, and we'll break them down soon. Article 1, Section 8, the Congress, again, the Congress, shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense. You wonder if we're paying for our debts, because we're about over $23 trillion national debt. So I don't know if we're paying our debts. We're certainly paying the interest on it. But the Congress has the power to lay and collect taxes, duties, imposts, and excises, and provide for the common defense. That means protect the country and the general welfare of the United States. In fact, that's where the word welfare comes from, that many Americans receive in part of entitlement spending, the welfare of the United States. But all of those laws, all those tax laws have to be uniform throughout the United States. The framers were afraid of the states punishing each other or trying to punish the federal government by taxing other states or anything the central government was doing in a harsher way than they would tax their own citizens. So that's why they have to be uniform. The Congress has the power to borrow money on the credit of the United States, which it has done and done and done and done. Now, this next one is a powerful one. And you could spend a month in law school on this very thing. The Congress has the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Well, the foreign nations is not hard to understand. With Indian tribes, it's not hard to understand either. We have our arrangement with the Indians is an entirely separate part of federal law. They are a sovereign nation. The Indian nation is considered a sovereign nation. But the one I want us to focus on is the power of Congress to regulate commerce among the several states. That is hugely broad. And we're going to tear that apart next time, but just know right now, they tried to pass Obamacare based upon the Interstate Commerce Clause. And what they said was, wait a minute, healthcare affects every one of the several states. It crosses state lines. How healthcare crosses state lines is an interesting concept, but it also only has to impact interstate commerce, even if it doesn't cross state lines. So they got you either way. Either it actually crosses state lines, like a bottle of Heinz ketchup in Pennsylvania, where it's made, the Heinz factory, a bottle of ketchup and a big 18-wheeler making its way all the way down through the states. Clearly, you could say that truck carrying that product, Heinz ketchup, is crossing state lines. Healthcare is a different thing. It's hard to say how healthcare crosses state lines, except it's a fiction of sorts, but that's only one branch of it. The other branches, or if it impacts what's going on in your state, impacts interstate commerce. And of course, from a healthcare standpoint, what's going on in Louisiana impacts other states, because people buy healthcare in Louisiana, and what they do in Louisiana, the provision of healthcare in Louisiana does affect other states. So they got you there too. It's a super broad power. I think it has been used way too much. And I'm proud that the US Supreme Court in the last probably 20 years has started to kind of back it off a little bit, saying, look, states have rights too, Congress. You can't just say everything impacts interstate commerce and regulate all of it. So the court has narrowed it, saying, look, you're overrunning the states here. There's a 10th Amendment. The 10th Amendment says those powers not expressly granted to the federal government are left to the states and to the people. And so states have I said that in the first session. The federal government and the state governments are co-equal powers. It's a system of co-federalism. The states and the federal government are equal. You might say it doesn't look like it, but they're certainly supposed to be. So the interstate commerce power has been reined in. And there's a number of other things in here, Article 1, Section 8, to establish a uniform rule of naturalization. It begins with Congress. Now, they've given the president certain powers to deal with immigration, which is how all our border control of our border gets resolved. The rule of naturalization is nothing more than how immigrants become citizens. And so we also have a separate bankruptcy regime, a legal regime dealing with bankruptcies. Bankruptcy is all federal law. To coin money, to print money, and to prosecute those people who try to print counterfeit money. These are all straight up congressional powers. To provide for the punishing of counterfeit, to establish post office, and to build roads across the United States, to promote the progress of science and useful arts, the framers called it, by securing for a limited time the power of authors and inventors to have an exclusive right to their inventions, to their writings, their discoveries. That's what we call patent and copyright law. So for that period of time, if you design something, if you create a new drug, if you create some fabulous device, for a period of time, only you get to sell it, use it, market it. When that's done, then a lot of other people get to there's all kind of drugs for a period of time, a very fabulously advanced drug, whether it's for heart health or, mental health or any other kind of health, comes on. It's a great discovery. That company that designed it for a while gets the exclusive use, money made from it. But then after a period of time, everyone gets to copy it. And that's where we have generic drugs. But anyway, for a period of time, you get the right. Nobody can infringe your invention. No one can infringe your patent, your copyright, your great discovery. The Congress gets to constitute tribunals inferior to the Supreme Court. We're going to do Article 3 later in the course. To constitute tribunals inferior to the Supreme Court. You know what that means? It means U.S. federal appellate courts, courts of appeal, and U.S. federal district courts, like we have one in Shreveport. And Louisiana is part of the U.S. Fifth Circuit Court of Appeal. Well, Congress could create new federal districts where judges would serve, and it could create a new appeals court. And from time to time, it does that. But it has the power to constitute tribunals, meaning courts that are inferior to the Supreme Court, meaning appellate courts and district courts. It can do things like define and punish piracy and felonies committed on the high seas. Occasionally, we send the Marines in when some group of pirates is harassing an American ship somewhere. You've seen those examples. We can raise and support armies, but no appropriation of money to that use can be for longer than 2 years. And Congress would have to do something different to get around that. But armies can be raised. That's a straight constitutional power Congress has to raise and support an army, to provide and maintain a navy, and to make rules to govern our military, and to provide for the calling forth of the militia. We have a National Guard. Our National Guard is both federal and state. And that's fascinating and we're going to talk about that later too. But the National Guard is based in the state, but they can be called up by a presidential power. The president has the power to call up the National Guard and send them to other places in the world. And one of the things is you can use the militia, and this was a recent debate. We have 1 minute left. Well, we'll get into the Insurrection Act. It's whether the president has the power to use the National Guard to stomp out some of the riots we're having in America right now. And we're almost out of time. We will pick back up with that. We will pick back up with Article 1, Section 8. And if you stick around, I will be happy to answer any questions. But it's just about 7 o'clock. So thank you again so much for being here. And I will see you hopefully in 2 weeks. And I know the video will be up soon. But thanks for jumping in the first part of the Constitution with us, the legislative branch of it. Okay, guys, if you're still with us, I'm going to be open for questions. I'm looking for where any questions might be. I don't see any. Keep in mind, you can always email me questions, as we discussed earlier. And it is at, I always want to say it correctly because we have so many different, it is, we have so many different titles. So constitution.royalalexander@gmail.com. Constitution.royalalexander@gmail.com. And so if you have questions, email me. And I'm looking for your questions now. And I'm clicking on questions. Okay, here's one. The Commerce Clause, the bane of lawsuits. And it is. The Commerce Clause is such an enormous power. I had to rush through this part. I'm more interested in explaining things thoroughly than I am in moving quickly, because I want you to be able to take notes if you want, and I want to emphasize the things that I think are most important. One of them is the Interstate Commerce Clause. It is such a broad power. Again, if all that's necessary for the Congress to exert its power over the states, if all that's necessary is for it to either actually have moved in interstate commerce, like the bottle of ketchup that started out at the Heinz plant in Philadelphia, Heinz ketchup, in an 18-wheeler, and worked its way all the way down through the United States to Louisiana. You could say that truck, that 18-wheeler, passed over a bunch of state lines and through a bunch of states. Okay, that passed in interstate commerce. So Congress can regulate that bottle of ketchup and say, this is the way you got to make it, Heinz. You got to seal it so it doesn't make people sick. You can't use too much salt. You can't. We have several major health agencies in the United States which will not allow bad food and drug is one of them, to be produced and then sold to consumers. And so these health and safety laws prevent a company like Heinz from making a bad bottle of ketchup that's going to make some people sick. And it has that power because of the Interstate Commerce Clause. So it's important, and we'll talk about something called the Dormant Commerce Clause another time. Today, I want you to understand this concept. It not only had to pass through the states physically to have moved in interstate commerce, but that's not enough, because how does healthcare move in interstate commerce? Healthcare is not a tangible thing like a bottle of ketchup. How does healthcare kind of float through the air and move through interstate commerce? Well, the second prong of the analysis is, does what's going on in Louisiana regarding healthcare, does it affect the other 50 states? And you'd have to say it does. What we do in healthcare here, especially if anybody who has healthcare in Louisiana moves, say, to Texas. Now they're living in Texas, but they're still getting their healthcare coverage from Louisiana. We've now crossed state lines there. But if it impacts interstate commerce, if it impacts it, not just if it crosses state lines, but if it even substantially affects it, you can regulate it. And so literally what we're left with is that there's nothing that if that's the rule, if that's how broad the power is under the Interstate Commerce Clause, there's nothing Congress can't regulate. It essentially can use that power to overrun the states. And for a long time it did. You know, we have a lot of laws, a lot of things were created from about 1930 on, strictly based on the strength of the Commerce Clause. So it's such an enormous power. And it's conceptually, I think constitutional law is the most conceptually difficult of all areas of the law. I mean, there's other difficult areas of law, don't get me wrong, but you have to be willing to accept certain concepts to be able to understand things like interstate commerce. And I'll say again that for 2 years, the argument with Obamacare was based on the interstate commerce clause. And people said, there's no way healthcare can move in interstate commerce. You're taking the power way too far. But the people who supported Obamacare said, oh, yes, you can, because it substantially affects interstate commerce, which it does. That's why it's such a broad power. But what did the U.S. Supreme Court do? Justice John Roberts, and it made lots of people mad, wrote the opinion, and what he said was, even though it never had been argued under the taxing power, it had been argued for 2 years under the interstate commerce power. But Justice Roberts got the case and said, you know what? I'm writing the majority opinion, and we're going to affirm Obamacare under the taxing power, because clearly we just went over the fact that Congress clearly has the power to tax. So I'm sure in his mind he's thinking, I think the interstate commerce clause ground upon which to base Obamacare is much weaker than the taxing power. So he converted it and said, we're going to assume you argued it under the taxing power, even though for 2 years, that's not what the argument was based on. It was based on the interstate commerce power. So Justice Roberts and the majority flipped and said, you know what? We're not affirming it based on what you've been arguing and all your briefs and all your oral arguments before us. We're not affirming it based on the interstate commerce clause. We're going to affirm it based on the taxing power. And we have it because clearly Congress has the power to impose taxes. We just went over that. So that's, it made a lot of people mad. Let's see, another question. Mr. Alexander, the Supreme Court is not supposed to make law and it's only an opinion. So can a state ignore a Supreme Court decision? That's a great question. To answer it correctly, I want to say, again, our system is one of co-federalism. The federal government is equally powerful to the state governments, and the state governments are equally powerful to the federal government. They're co-equal sovereigns. They're supposed to have equal power. And as I said earlier, you can question in this day and age, with the federal government being as enormous as it is, whether or not they really have equal power. But that's the idea. With that being said, if a state gets, I'll say this, the easiest way to say this in the framework of our time right now is to say, if it's based on a constitutional ruling, then the state's going to have to follow. It is. But if it's not, and the interstate commerce clause power doesn't grab it, then states are supposed to be able to follow their own laws. That's what, when a state's doing something, the framers intended for our 50 states to be little incubators, 50 little places where experiments could be tried. And if a state liked it, they kept it. And if they didn't like it, they didn't keep it. And a good example of that is, you know, and it touches the hearts of a lot of us, but the abortion issue. Roe versus Wade took the issue of abortion away from all 50 states and it federalized it. And it said, we're going to say as a matter of constitutional law that this right to abortion is a fundamental right under the Liberty Clause of the 14th Amendment. Well, that was a reach. There's nowhere in the 14th Amendment, the Liberty Clause, that says anything about abortion. You can find a right to privacy in the Liberty Clause of the 14th Amendment, I grant you. We all have a right to privacy. But that right to privacy doesn't include ending the life of an unborn baby. So that's the argument. But when the Supreme Court held and ruled in Roe versus Wade, they took away the power from all 50 states and said, essentially, we know best. We, the United States Supreme Court, know best. We're going to say that in all 50 states, we're not going to let all of you try abortion on your own and decide whether to keep it or not. Because people ask me, what would ever happen if Roe versus Wade were repealed? What if it were overturned? Then the power would go back to where I think it should have remained all along, to the states. That's being truthful to the Constitution. The framers said in liberal states, I think abortion is immoral. It is clearly the ending of a human life. That is absolutely my view. But I'm saying we live in 50 states. If you live in California or New York and you elect members to your state house and state senate and state house of representatives who support abortion and a governor signs it into law, I'm always going to oppose that, and I'm always going to think it's immoral. But that's your state doing it. I promise you there'll be a ton of states that outlaw abortion, like Louisiana and Mississippi and Alabama, maybe Texas, and just work your way up. Lots of states would flatly outlaw abortion. Some would outlaw it with a few exceptions, but that would be each of the 50 states deciding for themselves, closest to the people, where the people can vote them out of office, can raise hell, can go to Baton Rouge or the state capitol and picket and write the newspaper and put pressure on their elected representatives in the state house, state senate, scare them to death, make them change the law, make our law not allow any abortions, or we're not going to be abortions with 3 exceptions, or we're going to allow abortions in a liberal state, maybe, like New York or California. But at least each state would be deciding the laws of our state. That's at least a much more accurate, much more honest approach to the Constitution than what the Supreme Court did in 1973, when out of whole cloth, the Supreme Court decided, you know what, we know best. We think society is ready for abortions to be available in all 50 states. So we're going to take that power away from the states to decide about the issue of abortion. And we're going to say, we think abortion should be legal. We're going to say, under the Liberty Clause, the right to life, liberty, and property of the 14th Amendment, we're going to say liberty not only includes a right to privacy, which you can accept, privacy between individuals, but that right to privacy doesn't extend so far as to allow for the abortion of a separate life. It just doesn't go that far. It was a terrible decision. It's not at all based on constitutional law. There's no constitutional foundation for the Roe v. Wade decision. As Justice Rehnquist and Justice Byron Whizzer White wrote in their dissent in Roe v. Wade, this is nothing more than an exercise in raw judicial power. This is a judicial fiat. This is the United States Supreme Court telling the 50 states, we know what's best for you, and you're going to do what we say. And that, to me, is such a perversion of what the framers set up in our Constitution with our dual system of government, our co-system of federalism, states and federal. And it makes a complete mockery of it. And I think it violates it. I think it's wrong. And again, the issue of gay marriage, it's, again, the 50 states, according to what the framers set up in the Constitution, each of the 50 states should decide what they think about the institution of marriage. The Congress shouldn't, again, federalize the issue and say, we know what's best for the country. We are smarter than you. We know more than your stupid state judges and your stupid state Supreme Court. We're going to say that on this issue, like the abortion issue, we're taking the issue of marriage away from you, and we're going to define what marriage means right here at the United States Supreme Court. Even though we are 9 unelected, life tenured judges, we're appointed. We're life tenured. No one can ever remove us. We're going to decide what marriage means. So Louisiana, even though you want to decide marriage means a man and a woman, a biological man and a woman, we're going to say you can't. We're going to say you're going to have to recognize a marriage of 2 men or 2 women. But that's not what the majority of the voters in Louisiana want. Again, to be faithful to the Constitution and our system of co-federalism, you have to allow each state to define what marriage means. And again, I think it's an exercise in raw judicial power to say, we know what's best. We think we know what's going on in our society and culture right now. We We think what we say is more important than the framers setting up the rights of 50 states to define how they define marriage. Because again, there'd be a number of states who would allow for gay marriage and a number of states that would not allow for gay marriage. But again, that's in keeping with what the framers set up. With the 10th Amendment says that those powers not explicitly granted to the federal government are reserved for the states and the people. Nowhere in the 14th Amendment is there a mention of gay marriage. Nowhere in the 14th Amendment is there a mention of abortion. For the Supreme Court to take the step and say, no, we know what's best. And they also said, we don't have equal protection of the laws. But in order to say equal protection of the laws has been violated, there has to be a law in the first place allowing for something. And there's no historical precedent for allowing gay marriage or abortion. So it's not a violation of equal protection of the laws because there's no law that's being applied to only one group. There never was a law for gay marriage at all. There never was a law for abortion at all until the Supreme Court came and said, you know what, I would find it far more satisfactory if there was a federal statute that said all abortions are legal up to the third trimester or the first trimester. At least then we could raise hell with our U.S. representatives and our U.S. senators and decide how to vote when we vote for president. Because those are the elected branches. Those are the branches that are supposed to legislate. The House and the Senate, as we talked about, with the president either vetoing it or signing it. They're all elected. Because they're elected, they're all answerable to the people. The United States Supreme Court is not answerable to anybody. I don't think they think they're answerable to God some days. They're the highest court in the land. They're unelected and they're appointed for life. So when they make a determination that we know what's best about gay marriage or we know what's best about abortion, they're taking that away in a constitutionally illegitimate way. It's constitutionally illegitimate to take these decisions from the states because the states have the right under the 10th Amendment and other powers of self-governance. Louisiana has the right to govern itself within those strictures of the Constitution. But one of the strictures of the Constitution that's not in the Constitution under the 14th Amendment, I promise you, is either abortion or gay marriage. And again, I'm not addressing those issues directly. I'm saying the states should decide, and it shouldn't even be the U.S. Congress or the U.S. president. I think it should be more local. I think if a state's going to accept abortion or accept gay marriage, it needs to be decided in that state because these are major issues of social concern. And how do we address things? We vote, we elect people, we send those representatives to go speak for us. Here it's in Baton Rouge, where the state Senate, the state House, and the governor all meet in Baton Rouge. Let the state of Louisiana decide about abortion. Let the state of Louisiana decide about gay marriage. To me, that's the constitutionally appropriate way. It's the constitutionally legitimate way to do it. That is my only point. But there are many other areas also. But when federal law can always be repealed. Another Congress can repeal it. But once something is decided as a constitutional right, it's going to be hard to it's going to take a constitutional amendment to undo it, to say that, no, court, you did it wrong. And that's very hard to do. So you just got to know when the U.S. Supreme Court takes on and decides a constitutional issue, it is essentially doing it forever. Now, the thought has been since 1973 that if there were some conservative thinking justices, some justices who were strict constructionists, as we've discussed, who just interpreted what did the law say in 1973 about abortion? Where did the whole Roe versus Wade opinion came from? That was a Texas case. What did the Texas law say about abortion? The Texas law had spoken on abortion. And the Supreme Court, though, decided, you know what? We're not only going to apply this to Texas, we're going to apply it to the whole United States. We're going to say, abortion, you have a fundamental right to abortion. It just doesn't exist. So be honest and say it doesn't exist. Leave it to the states. People are free to live wherever they want to in this country. But you have taken a deeply social and moral issue away from the people and their local representatives, their state representatives and their state senators and their state governor. You've taken it away from them and federalized it. And I think that's illegitimate. And let's see if we got another question. Okay, that's a good question. What about executive orders? I want to explain how much time? Okay, we got about 10 minutes. What about executive orders? Okay, what are executive orders? I've not only gotten that question here tonight. Can you explain executive orders? But I've gotten it in other places. Sometimes I do TV interviews, sometimes I do radio. What is an executive order? It is said to derive from the implied power of the chief executive, the president. The federal government is enormous. The president is the head of the federal government. So when he signs an executive order, he is telling all those federal agencies and everyone those federal agencies impact that we're going to be doing things according to what my executive order says. But it applies to the federal government. It doesn't apply universally. But the federal government is so big, it feels like it does apply universally. But an executive order is a type of written instruction that presidents use to work their will through the executive branch of government. And keep this in mind, an executive order can only be used to pursue a power to execute a certain thing, to bring about something based on a power the president already has. So an executive order has to be based on a power the president already has. It can't be used to give the president new power. So right now, President Trump could sign an executive order. Lately, seems like every time he does, someone runs to federal court. And usually I have to say, in a particular court in a particular part of the country, where they know probably an injunction will be granted to stop the president's executive order. To me, that is an abuse of the judicial function. Being president is a powerful position. One of the powerful roles he or she plays is the powerful to tell all the federal agencies in the executive branch what the rule is going to be, what the law is going to be. But things have become so political and so partisan that typically any executive order gets stopped immediately. And, keep in mind, the president's the head of the executive branch. He's the commander in chief, and the Constitution in Article 2, Section 3 specifically says the president has to take care that the laws be faithfully executed. Those three things: take care that the laws be faithfully executed, the executive power as the chief executive of 1/3 of the government, and as commander in chief. Those are enormous powers he has to use, based upon which his executive orders can validly be issued. Any president has them. President Obama used them a bunch. President Trump has used them several times. Let me see if there's anything else I want to tell you about executive orders. Both sides will always say, oh, they're abusing their authority by using an executive order. But again, it's a broad power. It's a broad power. And again, all of this clash that always occurs, I think the framers intended it. I think the reason we have a system of checks and balances between, which is why it's so important for each branch, judicial, legislative, and executive, to stay in their own lanes, is because, and the reason they do it, the reason we maintain that, is because of the system of checks and balances. I mean, if the president ever goes too crazy with his power, the Congress can cut off the money. Because keep in mind, all revenue bills have to originate in the House. And if the Congress decided not to fund the federal government, the executive branch, that would force the president to the table. That's one of the checks and balances. And there's a bunch of them, and it's brilliantly devised. But I think the framers knew. I mean, they knew what they had to go through to get the Constitution written and drafted. It was very difficult. Again, when they were in that convention hall in Philadelphia. They weren't there to write a new constitution. They were supposed to be there to revise the Articles of Confederation, but they very secretively, quietly, confidentially wrote this constitution we have. And they had to keep the doors closed and the windows closed. They had no air conditioning. It was very hot. You know, it had to be very hot in those 5 months. They stayed in there every day, fighting through it, and they did it. But they had to keep the doors and windows closed so nobody would pass by and hear them talk about stuff and say, wait a minute, they're not in there revising the Articles of Confederation, they're doing something else. They knew how hard all that was, and then once they wrote it to get it ratified by 13 of the Confederate states, they didn't need all 13, they needed 9. But it's all remarkable. We're almost out of time. I hope, let me see if there are any other questions. Those are good questions. Let's see. Okay. Why aren't pay raises null and void? Okay. Why aren't, well, the reason pay raises aren't null and void is because, and they now kind of do it, it's almost like an automatic thing. It almost gets, they put in place so they don't have to face the controversy every time of they don't have to face the controversy every time of a pay raise vote. So if they agree to one, and it's usually done on voice vote very quickly and quietly, late at night, it doesn't take effect until the next Congress. I can only see part of that question, but let's see. If the Supreme Court law is unconstitutional, why can it not be null and void? That's a great question. That's from the doctrine of nullification. And what it would require is the states saying, you know what, we're not following that law. But of course, then the federal government could turn around and say, well, Louisiana, we can't force you to follow it, but if you don't follow it, we're going to stop. You still have to pay federal taxes, and we're not going to allow you to enjoy any federal benefits. We're not going to send Medicaid or Medicare money to your state. We're not going to send road and highway money to fix your roads and highways. We're going to deny federal funding if you don't follow this law. So the doctrine of nullification is the very thing you're talking about. It is a real doctrine. It just would require virtually a state to say, I could see Texas doing it. You know what, federal government? We're going to go on our own again. We're reseceding because Texas didn't really join the union in the same way the rest of the states did. Texas has always had a very rugged, independent bent. And I think that if a state were to do this, it would be like Texas saying, you know what, federal government, we're going to support ourselves. We don't want any more of your federal money because, and we're not following any more of your federal laws. We're going to govern ourselves. We'll have our own health care. We'll have our own food and health standards, safety standards. We're going to do it ourselves. If we want to tax ourselves, we'll tax ourselves. We're not sending any more money to you. We're not paying any more federal income taxes. That's what it would require, but that's a great question. It's called the doctrine of nullification. And I see we are right at 7:30. So I don't know who hung in. I hope that you did. But if you have other questions, or if I didn't answer these, I'm going to go back through the questions from right now and I will try to answer them. But thank you so much for joining us. We're going to keep plugging our way through this. And I hope you enjoyed tonight. I certainly did. Have a good night.